Welcome to Landmark Chambers Quarter Day seminar, which, as you'll see from your screen, is on the topic of mediation and Part 36 in property law. We're delighted to see so many of people in the room and online. My name is Myriam Stacey KC, and I'll be chairing today's session, and I'm joined by Lord Carnwath and Rupert Cohen, whom I'll formally introduce in a moment. So on to tonight's topic. The highly anticipated judgment in Merthyr and Churchill and Merthyr Tydfil clearly promotes the notion that mediation and other forms of alternative dispute resolution are a central and significant part of the litigation roadmap, providing robust judicial support for ADR by confirming that the court may stay proceedings in order to compel parties to engage meaningfully. Even for the most cooperative of parties, as I'm sure we all know, securing a successful settlement is by no means always straightforward. And this evening, what we plan to do is to cover some of our own experiences, suggest some strategic and practical ways in which parties may enhance the prospects of achieving a settlement, and finally remind ourselves of the protective framework offered by Part 36 of the CPR. So on to the speakers. Our first speaker is Lord Carnwath. He is, of course, a former Supreme Court Justice. He will require no particular introduction, but I will do my best. He retired as a Justice in March 2020 after a distinguished judicial career, which culminated in 8 years in the Supreme Court and as a member of the Judicial Committee of the Privy Council. He has extensive experience, both as a practitioner and as a judge, of the full range of property, planning, and environmental disputes, and he has been involved in many cases of great constitutional significance. Happily for us, he is now an associate member of Landmark Chambers, having rejoined us following his retirement, and he is available to undertake a range of professional engagements within his principal areas of expertise, which include arbitrations, expert determinations, evaluations, and mediation. Our second speaker is Rupert Cohen, who will also be well known to you. He has the advantage of being able to speak to you today from his perspective, both as a barrister representing parties and as an active mediator. He is a panel member of the property mediators and is ranked as a mediator in the leading directories. He also represented the Law Society as intervener in the Churchill and Merthyr Tydfil case. And finally, I am the final speaker. I specialise in property law, and my practice covers both commercial and residential property disputes. I regularly appear as a representative for parties in mediations, although I suspect Rupert will have something to say about whether counsel is necessary. Rather than mediation, I'll be talking to you about Part 36, which can be an equally powerful route towards securing a settlement, or at the very least, protecting a party's position on costs throughout the litigation. So that's enough from me. Let's begin.
Right, well, thank you very much for that kind introduction, Myriam. I suspect you're more interested in what Rupert's going to be telling you, which is much more about the nitty-gritty of mediation, so I'm not going to take very long, but we thought it might be of interest to hear the experiences of a rather sort of high-profile environmental dispute, as I'll call it, because it was a dispute which was very much in the public domain, and there was some question about whether mediation could possibly work in that context. So you can find out all about the background because it went to the Court of Appeal on an earlier case brought by a boy. It arose out of highly public complaints about emanations from a landfill site in the Midlands, which had attracted widespread complaints from the public. And I put there the description from the Court of Appeal judgment in the case of Richards and the Environment Agency, because a 5-year-old boy with health problems who was affected by emanations from the tip brought a case based on the Human Rights Act and took it all the way to the Court of Appeal and sadly lost. But as the Court of Appeal judgment records, From 2020 onwards, complaints had been received about foul-smelling odours coming from the landfill site, principal cause being hydrogen sulfide gas, and they describe what that can do to you. We were told that there had been about 45,000 complaints in a period of some months in 2021, more than the number of complaints made about all other such facilities in the country combined. So it's a very public case, and as you can imagine, MPs were involved. And so there was some, that case had failed, but they still, everyone was trying to work out what the answer was. And I think what didn't help was that the legal framework was complicated by overlapping jurisdictions. And I don't know how many of you are familiar with this part of the law, but one had the Staffordshire County Council as waste planning authority, responsible for conditions in the planning permission, while they had the Environment Agency as a regulator with responsibilities under the Environment Act for permits and enforcement. And then one had the Borough Council with duties to take action in respect of statutory nuisances under Part 3 of the Environment Protection Act. And now that jurisdiction, of course, goes back well to the 19th century Public Health Acts, the idea of the statutory nuisance. But it's quite important. But the statutes are not, as I say, are unhelpfully reticent about how these respective functions are expected to interact. But it was clear that the Borough Council, having identified a statutory nuisance, had an independent duty to act regardless to the lack of action by the agency. As you saw, the Environment Agency were defendants of the proceedings which went to the Court of Appeal, and the Court of Appeal felt they couldn't intervene under the Human Rights Act. So the Borough Council had to get on and do things. And they served what's called an abatement notice on the operator under Section 80 of the 1990 Act. Now, as you may know, an abatement notice is a notice which identifies a statutory nuisance, which clearly this smells seriously affecting the health of people. And it requires them to abate it, but it's not a very sophisticated remedy. It doesn't sort of tell them in detail what exactly they're supposed to do to remedy it. And what happens is that the operator then has the right to appeal to the Magistrates Court, and one can have a hearing in front of that tribunal. Now that's very suitable for a lot of sort of local nuisances and disputes, but it's not terribly suitable for a major complex dispute of this kind. But the notice does seem to have provided the stimulus for some further action by the operator, including the engagement of new experts. And this meant that by summer 2022, there was a reasonable degree of consensus about the action that needed to be taken to deal with the problem, perhaps less consensus about when and how it was going to be implemented. Now, the operator had appealed against the notice, and that was due to be heard by the local district judge in autumn 2022, and leading and junior counsel had been instructed. And I've quoted there from the Francis Taylor Building's website, which talks about this case. What they were faced with was a 4-week trial with directions providing for disclosure, the exchange of factual and expert evidence, and each party was calling expert witnesses on hydrology, odour, and land filling. So you can imagine the poor old district judge, normally dealing with fairly ordinary cases, suddenly faced with a month of heavy expert evidence on all these matters. And I think there was a sort of feeling that this wasn't possibly the ideal way to go ahead. And it was at this point in July 2022 that I was approached to act as mediator with a view to arriving at an agreed solution of all the outstanding issues. And I think there were 3 main factors which led the parties to agree to mediation in preference to the court procedure. First, of course, the unattractive prospect of a long and expensive hearing with highly technical evidence before a non-specialist judge. having been involved in cases like that myself as counsel, I can tell you it's not much fun for anyone. Even an experienced district judge is going to find it quite hard coping with that sort of material. But I think also very important was the fact that the issues would be within a fairly strict statutory framework. I mean, the issue for the judge would be, was there a statutory nuisance at the time of the notice, which was always and what was needed to abate it. Now, in a sense, that was all of historical interest because things had moved on since then. And what one really wanted was a much broader look at the practical solutions to the outstanding problems at the time of the hearing and how they were to be managed in the future. And in addition, I think what was needed was something which would satisfy the public that there was going to be a really effective program in place. And then the other problem about the district judge was he would decide the major issue, but the question of costs would be probably put off for another occasion and left unresolved. And that, and by the time I was involved, the costs were pretty substantial. So we had our mediation over 2 days in the offices of the solicitors Brown Jacobson in Nottingham. And we reached an agreement whereby the operator agreed to withdraw its appeal against the statutory nuisance abatement notice, subject to an agreed program of remedial measures and monitoring procedures. And this was subject to approval by the district judge, which was duly given. And importantly, the agreement also provided for the operator to pay a substantial contribution to the council's costs already incurred, and also the cost of future monitoring, and for arrangements for improved information to the community. So one ended up with a fairly complex agreement providing for how the measures that were to be put in place to try and improve the situation, how they were to be monitored, how the parties were to meet to review that, and very importantly, how the public were to be involved and complaint procedures to be set up. And all that could be done within the framework of a mediation, which you couldn't have expected to come out of a district court hearing. It's reported, as I say, there in the Local Government Lawyer, 24th of October 2022. And it also included a formal statement by me confirming the agreement and stating, as I set out there, general effect of the terms. Now, I'm not, of course, going to go into the sort of detail of the negotiations, but it was a very effective process in the sense that both having all the parties there, we were able to be very flexible about how we dealt with it. I've listed some points to consider there. Firstly, on the question of mediation as compared to the relief which can be claimed in court proceedings. As I say, mediation offered a potentially much cheaper alternative and the opportunity to cut through the legal and factual complexities to a more flexible and practical approach. Choice of mediator, probably not for me to comment on it, but I think it's very much a matter of horses for courses in these cases. I think the parties saw me as a senior legal figure with direct experience over many years of dealing with environmental cases, both as practitioner and judge. And I think it may have been thought that the involvement of a former Supreme Court judge would help promote public acceptance of any resulting agreement. I mean, there's quite an interesting point there because this was a case where one's not trying to just satisfy the parties, but very much to satisfy the wider public, including the press and the MPs. And so I think it was thought that having me there might give that sort of confidence. Whether it did is an interesting point, which I'll come to. Good working relationship between media and parties was critically important. I was very much assisted by leading and junior counsel on both sides, who were very cooperative, and we had 2 preliminary Zoom sessions with council to sort out the framework and the detail. Detail preparation is obviously essential. The mediator is fully briefed on the legal, factual and technical background of the case so that he or she can command the confidence of the parties in the discussions. A good working environment, adequate rooms for the parties and their advisors to meet separately and for joint sessions. So we had a sort of 2 rooms for the parties and their experts and separate room for me. And we were able to meet together and then meet separately, and that worked very well. The solicitors were very helpful with all that. Firm but realistic timetable. Parties in this case are allowed 4 days for the process, which I suspect was much more than normal. But I decided at an early stage that if we hadn't achieved an agreement within 2 days, we weren't going to. And that proved amazingly accurate. We reached confirmed agreement at 5 p.m. on the second day, and we were able to go home. I told them that I wasn't extending my hotel stay, so that I think may have helped to encourage them. All key parties present, I mean, that was absolutely critical. Not only the lawyers, but the main experts, but crucially the decision makers, with the necessary authority to conclude the agreement. And very important was the fact that when we got to sort of crunch points, particularly on things like costs, the 2 decision makers, the managing director on one side and the local authorities director on the other, were able to, we actually put them in a room together and said, get on with it, and it worked. And as I say, cost is terribly important. Of course, you've got to get, in a case like this, where the costs were running into hundreds of thousands, it was terribly important that one sort of established an early stage how that was going to be resolved. So that's really all I need to say about the case. As a sort of conclusion, I did, as I was going to be speaking on this, I was interested to know what's happened since October 22. And I sent emails to the leading counsel for the 2 parties, Jeremy Phillips KC and Mark Watson KC. And they came back, I'm happy to say, and saying that the agreement has stuck and lasted. I was a bit worried that I'd come up in front of you and be told that actually it had fallen apart, but it did work. The authorities say that the Jeremy Phillips working relationship between the 2 parties has changed fundamentally. And he says that although the mediation agreement committed them to meet regularly for 6 months, they've actually met monthly and continue to do so, and a very good working relationship has been established. There are continuing odor problems, but that's, and they're working on them, but there's a much better framework for dealing with them. I asked whether local residents have recognised a general improvement. The answer to that was, well, complaint levels continue, but there's a general improvement, but there's still problems. Jeremy Phillips said, interestingly, in terms of mediation, I would say that a mediated solution rather than a win-lose has been more difficult for the community to understand. It can be unhelpfully characterised as having done a deal. So there's always that problem in a high-profile case. I mean, a court proceeding produces a definite result in the public, whereas to some extent, even when endorsed by a former justice, it's seen as also slightly sort of second best solution. But I think overall, it's worked very well in terms of establishing a much better framework for continuing. And on the other side, the operators, they certainly say again, it's much more constructive and has achieved a much better framework for solving the technical problems, rather than, yes, to concentrate on the ongoing engineering and capping of the site without the distraction of complex proceedings, and to avoid significant further outlay on legal and expert costs. So I think on the whole it worked. It was a very interesting experience for me, and certainly made me feel that in a complex legal situation, particularly where you've got interacting legal frameworks, mediation in the right context can be very, very successful. So thank you for that.
Right. For the next 20 or so minutes, you are going to have the fortune or misfortune, as it may or may not turn out, of listening to me talk about the do's and don'ts of mediation. And this comes from my direct experience as a mediator. And I'm going to be focusing on what I think needs to be done beforehand, during, and in circumstances where parties get stuck to maximise the prospect of settlement in a mediation. And then I'm going to go on to talk about the future of mediations in a property context, following on from the Churchill and Merthyr Tydfil decision. So, what to do beforehand? You'll see on the screen 10 points. In square brackets, italicised, is the explanation for why it is that I think that which should be done is set out. And I'm going to go through them, some with more detail than others, but by reference to a fictional dispute about an opposed 1954 Act lease renewal of a hotel or B&B. That's just how I'm going to illustrate these. Now, the first thing I think that should be done, by beforehand, this means in the week before, but preferably not the night before the mediation. And these are what I think solicitors should be doing with clients. The first is to work out the top and bottom line with the client. Now, part of the reason why this tends to be quite useful is when you get to the nitty-gritty 4 p.m. of a mediation, people tend to focus on pence rather than pounds. By that, I mean they get upset about the small minutiae. Now, if you have 3-4 days before done a top and bottom line with the client, it can be a very, very good way of ensuring that they can move away from focusing on the small stuff and focus on the big picture. So an example of what a top and bottom line might be in this 54 Act context would be if your client is the tenant that's running the B&B, in the days before you would have sat down with the client and you would have identified what the maximum rent they could afford to pay on their lease would be. And obviously that rent is going to be a function of the projected income. You'll do future income streams, the rent to ensure that they get the sufficient profit margin they want. And that means that you'll know very early on if there's going to be a form of further lease contracted in or contracted out, what the most they'd be prepared to pay is, and that means that you can ensure that you don't end up focusing on matters that are actually non-progressive. In other words, identifying some rent which is way beyond the most that could be paid anyway. So number one is work out top and bottom line before you start. Now the second is a slight corollary of that, which is identify what matters. Now I always describe them as die in the ditch points. Now, often you get clients talk about matters of principle. Principles cost money. And in the cut and thrust of a mediation, and let's say the other side have offered nothing and it's 3 p.m. and everyone's really, really cheesed off. The die in the ditch points that your client is telling you will be radically different from the ones that they told you 4 days before the mediation. So it's really, really important to have a written record of what matters before people start getting cross and antagonistic as part of the mediation process. So again, in this context of the 54 Act example, from the tenant's perspective, you'd be finding out, what matters to them. Is it remaining in occupation? Is it getting a payoff? From the landlord's perspective, you're going to be saying, well, does it matter if they stay in there for a few more years if you can guarantee that they don't have security of tenure? So you get some kind of surrender of the 54 Act lease and you can grant them a contracted out short-term lease, for example. All of these things need to be fleshed out before the often very emotionally draining process of mediation really starts to bite. Formalities needs to be thought about in advance. This is something particularly for the legal team to be doing. So if I go back to that example of the 54 Act and we think about formalities, and by that I mean the ultimate document that conveys the outcome of the mediation. If you wanted to surrender this 54 Act lease and then have a short contracted out lease, you've got two options in reality. You're going to end up with heads of terms or you're going to end up with an agreement for lease. You're not in the context of mediation going to flesh out a 45-page lease in reality. Now, if you want it to be the latter, the agreement for lease, then you'll need to have a solicitor on hand to witness the tenant's statutory declaration to ensure that the agreement for lease is contracted out in turn. And that's the kind of things you need to be thinking about. Now, the reality of that is that if you're going to be, in this particular factual context, agreeing that they will surrender the 54 Act lease, they'll be granted a 3-year contracted out lease, you're going to end up in heads of terms. It might be that you can get a solicitor from another firm to come in and witness the stat dec and all the other Section 38 elements that you need to do to have the agreement for lease contracted out. But I mean, that's going to involve quite a lot of thought and organisation. So that kind of thing needs to be thought about in advance, because it so often happens in mediation that you get to 5 o'clock, you get a broad settlement and one party says, I want heads of terms, and it gives the other parties the jitters. They spent 7 hours hammering this out, and they rightfully or wrongly fear that the next day someone's going to turn around and say it's non-binding heads of terms, it counts for absolutely nothing. So that needs to be thought about in advance. 4 is, what additional information do you require from the other side? And what I hate with a passion is starting a mediation at 10 o'clock and finding the first 3 hours are wasted because one party says, well, I can't really make an offer and I don't really know where I stand until they give me this information. The other side then busy around firing off emails left, right and centre. They give the information, you spend an hour processing it. That should be done in advance. So again, in this post 54 Act example, what I would want is, if this is something that the tenant regards as important, would be it to be abundantly clear in the weeks before that they want, prior to the mediation, on the morning of the mediation, all evidence going to planning permissions on 31F, or evidence they've got the money for demolition. That needs to be threshed out in advance. It should not be raised on the day, because it becomes an impediment and it eats into precious time. 5 is important. You need to demand to speak to the mediator. Now, good mediators will always offer to speak. The best mediators will demand to speak. Now, the reason why it matters for your client is it's an opportunity for you to build a rapport with the mediator, but also to set the stall with the mediator. This is what matters for my client. And that means, rather than fluffing around for an hour and a half trying to work out what does and doesn't matter, you've already set that out in advance. It's also an opportunity to control the process, which feeds into number 8, which I'll come on to, which is whether you have the single joint meeting to start with. And if all of that is being communicated prior to the start of the mediation, then it maximises time and therefore success. 6 is obvious. Where are you going to do it? Boundary disputes, neighbour disputes, easements, always on site. I've done a number 1 I did 2 weeks ago, a dispute about a church wall that had fallen down in a graveyard, and it made a massive difference being able to walk up and down the wall itself and come to an agreement with the respective neighbours as to who's going to be liable for it, and cordoned off gravestones, that kind of thing. It made a huge difference being on site. Neutral venues, sometimes you might want to do it in a chambers, you might want to ask the mediator where they can do it. I've done a number in holiday inns, which that's also an interesting experience. Remote, sometimes it works. I mean, I've done a number of these where I've had one party remote and one party on site. So I will sit in my room and I will be on Teams, Zoom, and I'll have one party's sessions on the computer, and for the other party, I'll just pop next door and have a conversation. So that can work as well. 7, I love a deadline. I think deadlines are great, but they only work if everybody knows in advance. Do not at 4 o'clock on a mediation say you've got to leave in 2 hours' time. Deadlines are great for fixing attention and getting purpose. People understanding that there needs to be momentum early on, and this is not a mediation that's going to finish at 3 in the morning, but it does need to be made clear in advance that it's got to finish at 7. You don't necessarily need to provide a reason for it. I mean, it might be that someone's got childcare commitments, it might be that the venue closes, it doesn't really matter. But if you're going to do a deadline, which I always I think is very useful, then it needs to be expressly set out. Single joint meetings. You need to have thought about whether they're going to be useful in advance. There's a great debate amongst the 7 of us at the property mediators about whether we think they are a good thing. We've agreed that for the next 6 months, we're going to chart our mediation success with direct reference to whether we've decided to have a single joint meeting in advance to see if there's a correlation. Single joint meetings are what you're taught when you go on your accredited course. It always says you start the single joint meetings, you go into 2 separate rooms, you shuttle between the 2. There is a reason why that's what the course materials say. But in the property context, I tend to be pretty unpersuaded by single joint meetings. I can understand why in a commercial context it might work. But armies of lawyers, you've got 2 corporate entities. But in a property context, particularly when you're talking about emotions, and in that classic 54 Act, you know, someone's running this B&B, they put their life and soul into it, they've got lots of employees. To have a single joint meeting, which all too often becomes a willy-waving affair from the lawyers or a glorified therapy session from the client, is not a constructive use of time. But you need to have thought about that in advance. Choosing your mediator carefully. Some mediators are proactives, some passive. Positive energy is really important in mediation. I'm going to come up to kind of particularly how that tends to feed out in the later slides. But you've got to go into a mediation with the right mindset for you and your client, but the mediator has got to do it as well. And, you know, making sure that at all stages you remain this positive ray of sunshine that settlement will come even when it's 9:15 at night and everybody's on the verge of passing out. That really, really matters, because if the mediator loses faith, then everybody else will lose faith. And equally, you need to choose your mediator. You know, some genuinely are glorified email inboxes and have a very, very successful career doing that, but you need the right mediator for that dispute, or rather you need the right dispute for that mediator. Some mediators will quite happily sit there and say, I think your legal case is terrible for the following reasons. Now, strictly speaking, our governing body as insurers would probably say you shouldn't do that, but you know, there is definitely a place for it in the right dispute, so you just need to be alive to that. And as Lord Carnwath quite rightly said, you need the decision maker there. On the phone, I mean, there's just no point having a mediation if you're not going to end up with the ultimate decision maker being there at the point in time. So, what to do for mediation? Number one, be open with the mediator. I will sit down in my opening sessions and I will be quite blunt when I say to parties, I want to know what they think their weaknesses are. I want to know what they think their strong points are. Every single mediator in the first session should ask, by way of initial question, what really matters to you? Where do you want to be at the end of the day? And in that broad discussion, and obviously it's entirely without prejudice, it's entirely confidential, it remains within the room, it's really, really helpful if parties put their cards on the table. And occasionally I get a little bit frustrated when I say, you know, lawyers saying, you know, we want to have a private discussion. Of course, have your private discussions. But, you know, if you want to use the mediator to the greatest extent that you conceivably can, then you need to be honest with them. You need to set out what matters, what doesn't matter. You know, there might be things in correspondence that you get all bombastic about, but actually in reality, you don't really mind. That's what needs to come out in the first sessions for mediation. Offers. First offer should be identified before the mediation itself. So you weren't starting mediation at 10 and then spending 2.5 hours thinking about what your first offer is going to be. And that's what you should be doing in advance. But when you come to that first offer, think about doing alternative packaging. So again, if we come back to that 54 Act, it's posed. So if you think about the moving parts for any potential settlement, you've got tenure, you've got periods, you've got rent, you've got payoff. And what you might do if your client was the tenant, for example, is you might say, right, my first offer is putting forward 2 packages. The first is that you grant me 15 years contracted out at a depressed rent. That gives the landlord something because it's contracted out, so they know they'll get keys back. But from the tenant's perspective, they know they've got a decent chunky long term and they're not paying very much. Or the tenant might say, my alternative offer is to say, right, it's 5 years. It is within the 54 Act, but there's a landlord break on 6 months notice and it's going to be a bit longer rent. And you can see what that feeds into. What that's doing is fleshing out very early on, flushing out very early on what matters. Because if the landlord really cares about getting the keys back, then they're going to start negotiating on the first offer. It's going to be contracted out, I'll take that, but I'm not offering you 15 years and the rent should be more. If the landlord, however, thinks, you know, I'm opposing this, but I'm opposing this because I want to leverage the rent up. I mean, I know they've got to do it in good faith, but landlords' intentions do change, and it might be in the notice itself, in Section 25 notice, but you might be mediating a year later. And in those circumstances, you might find the landlord grasping onto the second, which is, I actually want market rent. This matters to me. Number 3, in the context of a mediation, I hate the C word with a passion. The problem with offers that say you pay my costs or a contribution to my costs is it attributes blame and fault. Now, if costs matters to you, negotiate an offer on the basis of no order for costs and put whatever contribution you want for costs and just lump it into the principal sum. It doesn't really matter what the figures are meant to be attributed to, apportioned to. What matters is the final figure. But as soon as parties start saying, give me X, Y, and Z and my costs, I mean, I tend to be pretty intemperate about it. I throw my toys out the pram. Just don't package it in that way. If you want 50 grand for costs, chuck it into the principal, call it no order for costs. And that means the day will always progress on no order for costs, rather than what you sometimes get, which is at 4 o'clock, someone says, oh, and you should pay my costs, and then everybody gets very upset. Number 4, start drafting when the shape of settlement becomes clear, and this means lawyers start drafting by 2 p.m. You should be armed with precedents. You'll know your boilerplate clauses for severance, your boilerplate clauses for confidentiality, warranties of authority, all of those. Have them with you, but by 2 p.m. you'll tend to know what the shape of the final settlement is going to be, and you should start drafting. And let the drafting continually update to reflect your offers, the other side offers, and that's the difference between a mediation that finishes at 7:30 and one that finishes at 2 in the morning. And when lawyers sit there, and I mean both solicitors and barristers gazing vacantly in the ceiling for 45 minutes while I'm with the other side, that is simply time wasted. And that feeds into point 5. Your standard property mediation tends to have 3 or 4 offers each side. Start at 10. I like to have the first offer done by 11. First offer tends to be a pretty small step. And by and large, that first offer has got to reflect, I say by and large, invariably it's got to reflect some form of compromise. And it's not just a compromise from the pleaded position. It should be a compromise from the last offer that was actually made. And it's very, very difficult for another side to digest if your first offer is worse than the offer that you made 3 weeks before and called back. I previously offered to accept 50 grand, you can now pay me 75. That's not a compromise in the way that the other side will perceive that word to mean. So the first offer, as I've said, should be formulated beforehand. It obviously needs to reflect a movement from the pleaded position, but I also think it needs to reflect movement from the last offer that's been made, because that forms the background, the parties' expectations when they come into the mediation itself. So you get the first by 11 o'clock. First step tends to be pretty small. Second step tends to be bigger. Third step tends to be quite small. Fourth step then tends to be quite bigger. You want to have your fourth and last offer in by 4:30, and then that allows for 2 hours for drafting. Now, all of this, I should say, is my dream mediation. This is what I would love to happen. Unfortunately, it's very, very rare. But I will say to parties when I speak to them on the phone, when I send emails to them in advance, this is what I would like. Now, sometimes doesn't happen because the client's not amenable to it, doesn't happen because of circumstances, doesn't happen because the lawyers haven't been put in funds or whatever reason might be. But in the ideal world, you'll be following 4-step process with the last offer at 4:30, everything signed, sealed by 6:30, and we can all move on. Number 6, avoid introducing moving parts late on, particularly moving parts that are not referable to the pleaded issues. Obviously, mediation, you can be as creative as you want to be, but if you're going to be creative, please be creative in the morning. Don't try and be creative at 5 p.m. in the afternoon when everything's done and dusted. So again, by reference to that 54 Act B&B, you might have agreed a contracted out 5-year term, and suddenly someone turns around and says, by the way, I need you to redo the front drive at 5:30. That's really frustrating. So try and avoid those. Rowing back on an offer, it's not really the done thing. It's not really okay. The great virtue of alternative offers is you can mix and match without it ever giving the perception that you've said, I'll take this, and then 3 hours later, I actually want more than that. Threatening to walk out, really? Really? Can we do that? If it's not going to settle, it'll become clear to the parties, but most importantly, it'll become clear to the mediator, and the mediator will be able to communicate that. But threatening to walk out, well, doesn't really add a huge amount. Saying things like best offer at 2 p.m. doesn't really add a huge amount, because then they'll just chip away and knock another 5 grand off, and it's not therefore the best offer you're going to make. Just got to be quite careful about the language, particularly if it's going to be inflammatory or antagonistic from the early stage. 7, stay positive. Solicitors, clients, big ray of sunshine attitude. A lot happens at the 11th hour. Clients will get very, very down over the course of the process, because it can be, and it often is, very emotionally draining for them. The last thing you want is the lawyers being a negative Nancy. Don't be a neggy Nancy, stay positive. Number 8, costs and interest are very easy to be flexible on. and you hear it time and time again, but I've waived my costs, I'm not waiving interest. It's cheap currency. Everybody knows it's cheap currency. It's not a great piece of salesmanship to say, I'm waiving my right to interest. And then people start claiming it should be 8% judgment rate, it's free judgment, all of this kind of stuff. Everybody knows it's cheap currency, so don't overvalue the benefit of giving that away, so to speak. So what happens if you get stuck? Take a break. Phone a friend. Look at pictures of your children, cats, dogs, little highlights. Just get yourself out of their environment for 30 minutes. Take a walk around the block, go and get a cup of coffee. Number two, I often think it's very useful doing a lawyers only get together. Mediator, one lawyer from each side. You don't want to come armed up to the max. It's very useful when the client is obstructive, is a slightly pejorative, but I shouldn't really use that. I just mean that the client is getting very wound in the process and it is very tightly strung. A lawyers only get together with the mediator. Obviously it's entirely WP, but you're feeding back to your clients, but it can be a very useful way of saying, right, my client is particularly wedded to this point. If you're flexible on this, we could be flexible on that. Why don't we proceed on that basis? And reciprocally, number three, client-only get-togethers can be very useful. And lawyers can be very difficult. And I had a mediation at the tail end of last year, which was a local council and a housing authority who'd had a fallout. And the lawyers were getting really caught up in the weeds, and the representative of the council, the representative of the housing authority had a good working relationship, got them in the room. 45 minutes later, they'd hammered out heads of terms. And it was lawyers that were making things difficult by being, obviously trying to fight for their client, but failing to, I think, see the bigger picture that the client ultimately wanted them to do, or getting too stuck in the minutiae. Sealed bids are often very useful. Sealed bids are, what tends to happen is you'll put 3 bids in an envelope. 3 envelopes, I should say. First bid, second bid, bottom line or top line respectively. Give those envelopes to the mediator. Mediator will open the envelopes. And if there's any overlap, so one person says, I'll pay 60 grand, the other person says, I'm prepared to accept 40 grand, you've got your overlap. So you know there's going to be a deal. And depending on the terms of the agreement to the sealed bid, you can slice it down the middle, or you can tell parties where it is. But the great virtue of sealed bids is it's a way of getting parties that are terrified of giving away too much to actually basically gamble on the process, but without doing so in a way that feels like they're giving away far too much far too soon. So you can put 3 bids on the table. My first offer is, I'll pay you 40 grand. They say, I want 60. That's not going to work. You go to the second, you go to the third. And then with the third, you can either have a binding settlement, you splice down the middle, you can then put it to each party that you're going to have settlement. These are the 2 points of reference, and then they can start talking about the middle ground. But sealed bids is very good when you've got parties that are being very tentative. 5, if there's just a huge amount to talk about, or if there's been very, very a breakthrough very late in the day, then do a day 2 and agree mediation privilege continues. Might be the next morning if everybody's free. You might do it by email. I've done a number where we've kind of got there but not quite got there, and we said, right, let's continue this by email the next day, or I'll be available from Zoom for 2 hours the next day. You agree, all the mediation privilege continues, and it just means you can get a little bit more thrust in the process. Number 6, it's often sensible, if you're comfortable with your final position, which haven't been accepted, to repeat the offer in a Part 36 the following day, because then you've actually leveraged the process to the best of its possible ability. If you can live with that offer, put it down as Part 36. If you gave it a mediation, put it in a Part 36, and it might either ensure that settlement comes shortly thereafter, or it can be very useful cost protection later down the day. The best mediators are demanding, encouraging, cajoling, always in a positive, friendly way, but they will push back, they will reality test, they will say, I don't think that offer is realistic, or if I were you, I wouldn't be doing that, but always with momentum, because mediations are about momentum, and that's how it is that you actually engender settlement. Now, I'm just going to spend the next few minutes talking about Churchill and Merthyr Tydfil. I was instructed by a very talented solicitor, which I can see in the back of the room, on behalf of the Law Society, and we intervened along with 3 other bodies before the Court of Appeal. It was heard by the Lady Chief Justice, the Master of the Rolls Deputy Head of Civil Justice. There were 4 silks, 5 interveners. It really was a kind of council of the great, with probably the notable exception of me. Halsey is a case that I'm sure you've come across in practice. Actually, Halsey itself deals with when a refusal to mediate is unreasonable for the purposes of costs. Under Part 44, it's one of the relevant factors under 44.2, you need to think about conduct of the parties. That's what Halsey was about. But there was a comment made by Lord Justice Dyson, who I think was there at the time, maybe it wasn't. But in paragraph 3 of the judgment, he said that in his view, to oblige truly unwilling parties to mediate would amount to infringement of a party's Article 6 rights. And that became basically the established law until Churchill. So for 20 years, we have all been working on the assumption that the court cannot order parties to mediate. And what we mean by ordering parties to mediate is to say, this claim will be stayed until a mediation takes place. Or if you do not mediate, here is the sanction. The sanction could be anything from a stay, for example, or it could be strikeout. And I mean, there's so many different shades of colour within those two boundaries. And what the Court of Appeal decided in Churchill and Merthyr Tydfil was that the court does have that power, that the comments of Lord Justice Dyson, as was what Obiter, when he was referring to infringements of Article 6 rights in terms of compulsory mediation. And that is, I do think, will fundamentally change the litigation landscape. It now means that the court can has the power to stay a claim until a mediation takes place. Now, whether the court should do so, of course, is a different matter, and you'll see in the third bullet point that what the Court of Appeal decided to do was say, right, this is a matter for the discretion of the particular judge in case. The Bar Council and we, the Law Society, set out various factors we thought were relevant, and they're summarised in the bottom bullet point, and the Court of Appeal said, yeah, these are relevant, you might have other factors, and you'll see some of them there. What I will say when you look at these factors, 11 factors that you see in the bottom bullet point, is that they are there to cover the whole panoply of different cases. The reality in property is that a good reason not to have mediation is going to involve things like cost, delay. The nature of property tends to mean that many of these factors, it's very different when you've got public law principles that have got wide ramifications across a great strata of society. It is slightly different in the context of the conventional property dispute, which talks about private law rights. And actually the factors that will militate for or against mediation will tend to be, I think, things like cost and delay. So what does this actually mean for us going forward? From a practitioner perspective, prior to CCMCs, and the awareness of decision will slowly bed in. We'll no doubt have a decision from one of the business property courts, which is specifically devoted toward the property, that will then provide a bit of a jump start in terms of mandatory mediations. But ultimately, you and your clients need to have a position on mandatory mediations prior to the CMC. You're going to argue for it? Do you want it? Do you want to stay to mediate? If you do, what are your reasons? And if you don't, why not? I personally suspect the directions questionnaires are going to be changed very quickly. At the moment, if you think of the DQs, it says in number 1, do you want to stay for a number of months post CMC to try and settle the claim? I suspect there'll be an extra question which is going to say, do you want to stay for mediation? If you've got a multi-track case, property case, it's cost budgeted and both sides are represented, have got the money, is there a cogent reason not to mediate? And I think that can be quite difficult to suggest that there isn't. So I think over time, it's going to become the norm. The real pinch points are going to be, well, at what stage should you be mediating? Post-CMC, pre-disclosure, post-disclosure, same goes to witness statements, expert evidence. There's going to be a fight about that. There's going to be fights about the identity of the mediator and the cost and the like. And actually, the Commercial Court Guide's got quite a good solution to that at the moment, which is one of the standard appendices court forms says that if you can't agree the identity of the mediator, both sides choose 3 with the costs and then email it to the judge, and the judge chooses. But the kind of satellite litigation, so to speak, I think is going to be about timing and identity as much as anything else. Fast and intermediate track, you've got fixed costs, so the parties are just going to have to absorb the cost of the mediation, or they're going to have an agreement as part of the mediation agreement about who pays costs. The bigger questions, is mandatory mediation going to work? At the moment, success rates for voluntary mediations are above 70% broadly. It's going to be interesting to see where you've got mandatory mediation, whether that's going to change, particularly in a property context. The mediation market's going to have to change if there is a massive boom in property mediations. I mean, the reality is a lot of property is mediated anyway, but if you're going to see a marked increase, you have got questions about whether there are enough established mediators. I quite pompously would say that I'm one of them. But as I look at the market, you've got 7 of us at the property mediators, you've got the 2 Beverleys and Patrick Ipos, you've got Bria Chaos, but I mean, it's not like it's bursting with well-known names. And I think that is going to be a problem. And it's an institutional problem as much as anything else, because there is no mediation governing body, there's no bar council, there's no SRA. The accreditation is a 2-day course. You get lots of prospective barristers coming off the training, having done 6 hours and claiming to be accredited mediators. Actually, the name itself doesn't really connote anything of value anymore. So if you've got a massively increased demand for good mediators, the market is going to need to change to 1, accommodate them, but also 2, ensure that they can be properly trained, because mediation is all about experience on the job as much as anything else. And it does seem to me the market's got to evolve, because you don't have chambers or solicitors firms that provide the training. The reality is there's only 15 of us that would hold our hand up and say that we do it, and you get requests for work experience and observations left, right and centre, but the market will need to change if there is a major uptick in demand for mediators in this context. And that brings me to the end of my stint. So I'm now going to hand over to Myriam.
Thank you, Rupert. Right, so for the next 25 minutes, I'm going to move on to an entirely, well, not entirely, but a different topic, namely that of Part 36 and the protection of property disputes. So as I said at the outset, Part 36 is an important part of the litigation toolkit, and it should be used in conjunction with mediation in terms of your planning. It assumes a central role of the litigation planning process, and as Rupert said, it can either be used after a mediation which is unsuccessful, but also it can be used at the outset, so you have an eye on Part 36, when to make one throughout the litigation. And therefore, I think we need to start with a bit of a refresher, because it's a self-contained code which contains a number of technicalities, which I'm going to run through. So in terms of the formal requirements, the starting point is 36.5. It's up there on the slide. You'll receive all of these, so no need to take notes unless you want to. But the fundamental requirements as set out there are that an offer, in order to be a valid Part 36, needs to be in writing. It has to make clear that it's an offer made pursuant to Part 36. It has to specify a period of no fewer than 21 days within which the defendant will be liable for the claimant's costs if it's going to be accepted, although bear in mind that 21-day period doesn't apply if you're less than 21 days to trial, for obvious reasons. And it needs to make clear whether it covers the whole or part of the claim or the counterclaim, and that's a nuance that I'll come on to in a moment when I'm looking at the practical implications. Note that a Part 36 offer can't be withdrawn until after expiry of the relevant period. That's the purpose of the relevant period. If an offeror does try to withdraw the offer within the relevant period, the person to whom the offer is made may still accept it, may still accept the original and ignore effectively the withdrawal. And if that isn't accepted, then the withdrawal is deemed to take effect on the expiry of the relevant period. And that's to be found in 36.94 there. And then finally on this slide, it's a Part 36 can be time limited, so you can expressly undercut, if you like, or limit the time to alter the effect of the relevant period, which has the effect of withdrawing the offer if it's not accepted by a particular date. Given the need to ensure compliance with a number of procedural requirements within the relevant rules, it's worth noting, and that can be fairly onerous, it's worth noting the use of form N242A. And as Mr. Justice Pepperell said in the Essex CC New BBWA's case, most of the difficulty would be avoided if parties did use that form when they make their Part 36 offers, but that's not invariably the case. Standard letters are often written trying to kind of tick the procedural boxes, and their way of short-circuiting all of that, making things rather clearer and more certain would be to use the prescribed form. The purpose of making a Part 36 offer is plainly to protect your position and to secure the cost protections which generally follow if you beat it. But it's worth bearing in mind that those cost consequences are not an absolute. So even if a Part 36 offer has been made validly, the court does have a discretion to disapply the regime where it's considered unjust for the cost consequences to follow. And so it can be displaced where the court considers it would be unjust to make the usual order. And whether or not the court will do that requires the court to take into account, in making that determination, the court has to take into account all of the circumstances of the case when considering whether or not it would be unjust. And there are specific factors that are included in 3617(5), which include, not on the slide, but the terms of the Part 36 offer, the stage of proceedings when it was made, the information available to the parties at the time, the conduct of the parties, and whether it was a genuine attempt to settle. So those are certain factors, but it's not an exclusive list. So that's disapplication of the cost consequences. Let's look at what those cost consequences are. This is a table, a slide setting out the consequences if an offer is accepted. The relevant rule is 36.13. If an offer is accepted within the relevant period, that's the left-hand column, the claimant is entitled to its costs up to acceptance. If it's accepted outside the relevant period, the right-hand column, the claimant's entitled to the cost up to the expiry of the relevant period, so that's the 21-day period. And then the accepting party or the offeree pays the offering party's costs up to acceptance. So to give a practical example, if you have a claimant who makes a Part 36 offer fixing a 21-day period, and say the defendant accepts on the 25th day, the defendant would be liable to pay the claimant's costs up to the 25th day because that's the date of acceptance. If, on the other hand, the defendant makes a Part 36 offer fixing the 21-day period and the claimant accepts on the 25th day, say, the defendant would be liable to pay the claimant's costs up to the 21st day because that's the relevant period, right-hand column, and the claimant would pay the defendant's costs up to the 25th day, which is the date of acceptance. Cost consequences if an offer is rejected. So let's look at the left-hand column. It's a scenario where you've got a claimant's Part 36 offer, the defendant doesn't accept it, and the effect is set out in the left-hand column on the slide. So if the claimant wins, but fails to obtain more advantageous terms, the usual cost rules will apply. If the claimant wins and obtains at least as advantageous terms, so the offer or more, then the defendant must pay, and you'll see 1, 2, 3, and 4 there. So you've got interest on damages up to 10% from the expiry of the relevant period. You've got an additional amount of up to 10% of damages, up to a maximum cap, costs on the indemnity basis from the expiry of the 21 days, plus interest on those costs. So I'll give you an example again. You've got a claim, imagine, of £10,000. The claimant offers to settle for £9,000. The defendant rejects. If the claimant recovers £8,000 at trial, so doesn't beat the offer, the usual cost rules apply. If the claimant recovers £9,000, so beats the offer, at least as advantageous as, the Part 36 consequences follow. So the defendant must pay interest of up to 10%, so that's £900, an additional amount of up to 10%, claimant's costs and interest on those costs of 10%. And then right-hand column, if the defendant makes a Part 36 offer, which is not accepted by the claimant fails to obtain more advantageous terms, the claimant must pay the defendant's costs from expiry of the relevant period plus interest. If the claimant wins and obtains more advantageous terms, then it's the usual cost rule. So again, to take the example of the £10,000 claim, defendant offers to settle the claim for £9,000. Claimant rejects that because he wants 10. If the claimant only recovers 8 at trial, so doesn't beat the offer, the claimant must pay the defendant's costs from the expiry of the relevant period on the standard basis plus interests. If the claimant, on the other hand, recovers £9,001, so beats the offer, the usual cost rules apply. So those are the consequences. Let's move on to some practical pointers. Part 36 is a law unto itself in the sense that it's a self-contained regime set out in that section of the CPR. which means for the most part it escapes contract law, and that manifests itself in two different ways. Firstly, a Part 36 offer does not require the same level of certainty as a contractual offer. And secondly, the requirements of Section 2 of the Law of Contract Miscellaneous Provisions Act, the Law of Property rather, it should say, not contract, Miscellaneous Provisions Act 1989 do not apply. So I'm going to unpack that briefly. In terms of certainty of terms, Adams and Options UK, which is a fairly recent case, provided an opportunity for the court to consider the level of certainty and the detail required in the context of a Part 36 offer. So in Adams, the claimant made a short Part 36 offer, fairly cursory offer, setting out the terms, which were that the defendant should pay just over 60,000 to the claimant, take ownership of various storage pods that were in issue, and should pay the reasonable cost of the claimant. In the claim, particulars of claim which had been pleaded had stated that full particulars of loss would be provided in a schedule of loss and set out in more detail what the loss was, but that was not in fact provided. What the defendant subsequently said was that the offer, the claimant's offer in this short form, wasn't sufficiently certain and could not therefore properly be considered in the context of the litigation, in the absence of the schedule of loss which had been promised, and therefore on that basis the cost consequences shouldn't follow. Did that work? Well, the court, as a starting point, confirmed that the claimant had beaten the offer because the court awarded damages of 92,000, which was above the 60-odd thousand that had been offered. And Lord Justice Newey gave the lead judgment, and in relation to the certainty required, held that although contractual principles are relevant to interpretation of a Part 36 offer, Part 36 nowhere stipulates that a Part 36 must have the certainty that a contractual offer requires. There's a facility, it was noted in 36.8, entitling a party to ask for further information. And essentially, a valid Part 36 offer can still, as I see it, leave some matters, especially of mechanics, to be further defined. So the argument by the defendant, which is a bit of a triumph, frankly, didn't succeed. And then dealing then with certainty as in terms of the application to property interest, because as we all know, disposals for interests in land require compliance with statutory formalities. And how do the two therefore interrelate? Well, in Orton and Collins, that point was considered. It was a partnership dispute in respect of a law firm, and the claimant had served a notice of dissolution and had commenced proceedings, made a Part 36 offer, which included an obligation for the defendants to pay the claimant to dispose of his, i.e. the claimant's interest in a law firm and premises. So involved the disposition or the proposed disposition of an interest in land. The offer was accepted by the defendants, and it was subsequently sought to argue that, by the claimant, that there was no settlement agreement at all, no contract, no enforceable contract, as the Part 36 offer and its acceptance concerned the disposition of an interest, and there was not compliance with Section 2. The matter came before Mr. Peter Prescott KC, sitting as a Deputy High Court judge, and he accepted, before we get to the issue point, he accepted that usually a Part 36 offer and acceptance will create a contract. However, because of Section 2, a Part 36 offer and acceptance concerning the disposition of land will not, in and of itself, create an enforceable contract. So the issue he had to decide, as set out at the top of the slide, was whether a Part 36 acceptance that for some reason creates no contract can nevertheless be enforced by an application to the court. It's an interesting point, and in paragraph 61 you see there was reference to the underlining policy context, which was said to be that if parties who are before the court choose to employ machinery prescribed by court rules, they must be taken to submit to the consequences, namely that if the offer is accepted, the court may enforce it. So he didn't have much sympathy, much patience, frankly, for the claimant's subsequent argument that the mechanics or the absence of compliance with formalities were something the claimant could rely on. And then he went on to say, I therefore hold that it need not be a contract that is being enforced, and that the regime of Part 36, while it may well give rise to a contract under the general law, does not depend on contract law. The obligation that arises is not primarily contractual, it is sui generis. It is part of the court's inherent jurisdiction, now regulated and clarified in Part 36 to fulfil the judicial function of administering justice according to the law, which includes the settlement, addressing the settlement of disputes. The upshot is Section 2 can't be used to escape the Part 36 regime. So that deals very rapidly with certainty and the interaction between Part 36 and the disposal of interests. I'm just going to turn to a few other practical pointers, starting with service. And starting point here is that 36.72 confirms that a Part 36 offer is made when it's served. And it expressly refers to the rules of service in Part 6. Okay? So no special service provisions, Part 36. Part 6 then goes on to allow for service by other means of electronic communication in addition to your usual stuff that's set out on the slide. And that's said to be in accordance with the practice direction 6A. 6A, paragraph 4.1, expressly requires that a receiving party must have indicated in writing that they're willing to be served with an email and to have identified the email address to which it be sent. And as an aside, it's often forgotten that paragraph 4.2 goes on to say that a serving party must, so it requires a serving party to ask the receiving party whether there are any limitations to their agreement to accept service. So those are the requirements. So what happens then if a party fails to comply with PD 65 but purports to serve by email anyway? And that was a point that was raised in the London Trocadero case, where the defendant argued that the claimant's failure to comply with paragraph 4.1 in that case of the practice direction invalidated the service and invalidated the Part 36 altogether, so that the cost consequences would not follow. The claimant, in turn, sought to protect its position by relying on the case management jurisdiction in 3.10, where it said that where there's an error of procedure, it won't invalidate any steps in proceedings unless the court so orders. And Mr. Justice Voss said that an order invalidating the offer would be a triumph of form over substance, and therefore gave the argument that there was a procedural irregularity which ran across the Part 36 offer pretty short shrift. And in making that finding, he referred to the fact that it was clear that there had been receipt and that no complaint had been made. And in those circumstances, you'll see the emboldened bit at the end of the slide. He accepted that a failure to comply with rules of service should not be taken lightly. But really what he was doing here was focusing on the purpose of service, which is to ensure that the contents of a document come to the attention of the recipient. The key question was on the fact of whether it had in fact been received, and that given that receipt had been made, no complaint and no prejudice, he came to the conclusion he did. And that approach was followed in the Cole-Donnell case, where the court also refused to invalidate service despite a failure to comply with the practice direction. So the question which is then follows is whether there are any consequences flowing from defective service at all. And the answer to that is maybe. So in London Trocadero, it was held that there might be cost consequences. And Mr. Justice Voss in that case did say that the procedural failure justified an award of only some of the cost consequences under the unjust, you'll recall, general jurisdiction, because cost consequences not absolute, there's an inherent discretion. But that wasn't, you'll see at the bottom of the slide, followed in Cole-Donnell. So it all depends on the facts, and you have to consider each case on a case-by-case basis. And then finally, in terms of practical implications, we've got pleaded issues. Part 36.2a refers to the fact that a Part 36 offer may be made in respect of a whole or part of a claim or any issue arising in a claim. So that's the relevant rule, and that appears to be fairly straightforward. But is it? So where claims are mentioned but not yet formally pleaded, and that's given rise to some uncertainty on the face of the case law. So in Hurtle and Saunders back in 2018, Lord Justice Coulson said that the wording of 36.23a, which is set out at the top of the slide, i.e. a claim, counterclaim, an issue, the whole or part of, or any issue that arises in a claim, counterclaim, or other additional claim, it was held to refer to pleaded issues. and only issues which form part of the proceedings. So therefore, a new claim which has been intimated, but which is not part of the pleadings, is not called. So that was the finding in Hurtle. However, in AF and AB, which is another Court of Appeal decision, it was held, and this was a case incidentally decided 8 years before Hurtle. It wasn't referred to in Hurtle, but the Court of Appeal gave a much more generous construction of the rule. In that case, an offer was made in relation to a counterclaim, hadn't yet been pleaded, albeit that the defendant had expressed an intention in correspondence to amend the pleadings to incorporate it in the future if needed. And the Court of Appeal concluded the fact that the counterclaim had not been pleaded, formulated or pleaded, did not of itself matter. That case, as I say, wasn't cited in Hurtle. And then we get on to Caloney, where it was decided the year after Hurtle, differently constituted Court of Appeal in a judgment by Lady Justice Asplin sought to settle matters. And that Court of Appeal unanimously declined to adopt the strict construction in Hurtle, and held that the phrase a claim or part of a claim or issue should be interpreted to mean claims that had not yet been issued. They sought to distinguish Hurtle and refer to the fact that, you'll see there, a party is entitled to make a Part 36 offer at any time, including before commencement. Therefore, it can't be correct that a Part 36 offer can't be made in relation to a counterclaim before that claim has been pleaded. So it's difficult in light of that to see how Hurtle can stand. Worth bearing in mind, the Court of Appeal in Caloney sought to distinguish Hurtle and distinguished it on the basis that Hurtle was concerned with an offer made in relation to a proposed amendment to an existing claim, as opposed to an unpleaded counterclaim or issue. There therefore, it seems to me, remains a certain degree of uncertainty in relation to amendments, which change the nature of the claim that's there. And even if Hurtle can be disregarded entirely, it seems that there's also uncertainty as to whether the manner in which the proposed claim is to be articulated sufficiently clearly, and how clearly before it can qualify as a claim under Part 36. So there are uncertainties arising from this, but it might be said that uncertainty is what keeps us all in business. So thanks for listening. That brings us to the end of our series of talks. And if you have any questions, please don't hesitate to put up your hands and ask us, because we've got a little bit of time left over. Q&A. Yes, please.
Two questions. First one for you, in terms of Part 36. I'm sure there's a simple answer to this, I just really don't know. But just to go back to the old question of looking at sealed offers under Calder Bank and Calder Bank. I'm forgetting about 30.
Well,
it's going to be much simpler then, aren't they?
Yeah, I think that's right. And I think Calder Bank offers still are used, because often Part 36 complicates things overly. You have to tick every single box in order for it to qualify as a Part 36, and not every case lends itself to that. Obviously, the advantages of Part 36 is if you've got the binary situation, if you beat it, you can work out what the cost flows are, and that, I guess, strengthens it in terms of its value, and it focuses the other side's minds perhaps more acutely than a basic Calder Bank might. But they're both part of the toolkit. It's just a question of a case by case as to which one you want to use.
So the simple estate agents, I'm quite entitled to continue.
Absolutely. Yeah. Part 36 doesn't do away with Calder Bank.
And so just we've got for you very quickly. I really don't know this, but I'm very interested to understand. Can a mediator ever be liable for negligence?
It's all about the T's and C's, but all of our T's and C's expressly state, I think the Civil Mediation Council propagate them, and the same goes for our insurers. All of them say, you cannot claim against us, we can't be called as a witness. I mean, I really struggle to see what the duty of care would actually be.
Possibly releasing information which shouldn't be done, and I don't know, and I'm not trying to find a reason for negligence for a mediator. On the contrary, that would be a line in the sand where a mediator was careful.
Yes, I mean, certainly on the confidentiality provisions, but as I say, I mean, the T's and C's unanimously state that we can't be called as witnesses to what's taken place. But you're right, and if the mediator goes spouting about what took place, they may well find themselves in trouble.
And indeed, that's why you'd have to have your PI cover.
Exactly. And that's why our PI cover is expressly referable to these standard forms of the Civil Mediation Council propagate.
The insurers would insist that you say that you can't be liable.
If there are no questions from the room, excellent, thank you. Yeah.
It's just in relation to the Churchill case. I was just wondering if you thought that a result of the Churchill case was that the court has the power to require parties to mediate on a certain day.
I think the way it's going to be made manifest is that it's going to require the parties to mediate by a certain point. I'm not sure on a certain date. I mean, it certainly has the power. It's a case management power. You can, but by and large, when you think of directions, it's do things by a certain time, witness statements by a certain date. I can't envisage a court saying you have to mediate on this date, but I can certainly see it saying you have to mediate by this date.
And indeed, going that far might be said to be not proportionate. So you remember the conditions of the court's jurisdiction, it's not unfettered, it needs to be justified. Any other questions?
Yes. One for Rupert. Have you been involved in many 1954 Act lease renewal mediations? And if you have, in your experience, at what point does that mediation happen? You touched on it could be for the parties to decide, but obviously at the beginning of the process, often there's lots of lease terms to agree. Towards the end, it might just be rent, but where do you think the sweet spot is?
My gut is the sweet spot is earlier rather than later, which is slightly unusual. But the reality, if you think about opposed lease renewals particularly, is that the landlord's only got to prove their intention under F4G at the date of the hearing. So what needs to take place is that if you're going to have a successful mediation, which is going to come early in the process, then you save costs, the landlord has got to vomit their information up earlier. This is what we've got by way of planning permission. This is our intention under G to occupy. This is the evidence. These are our corporate proposals. This is our business plan. This is our financing. And then you mediate off the back of that. Because, you know, if you wait for disclosure and witness statements, all that inevitably happens is that things get updated because it's the intention at trial that matters. So if you really want to save costs, what the landlord needs to be doing is proactively disclosing things, and then you can get it.
What about for unopposed lease renewals?
I mean, unopposed, ultimately so much of it comes down to expert valuation evidence on rent, doesn't it? So, I can absolutely see a case when you've got, you know, the usual kind of miscellaneous terms about MEES regs and things like that, they're in dispute. But the real buck tends to stop on rent, in which case you're going to want your expert evidence, I would have thought. But I mean, it doesn't have to be in a formal expert report. You can mediate with experts in attendance, but it's very difficult for parties to realistically mediate a rent for, you know, a future term, which would be somewhere between 0 and 15 years without properly knowing the position of experts. So I think you would have wanted reports exchanged. Which
leads me, if you don't mind, into following on from the valuation point. There are benefits of formal mediation, but there are other forms of ADR. Do either of you have any thoughts about what kind of case, and it might be that's an example of a case where you don't need a formal mediation, but you can have a round table, you can have a principal to principal discussion, you can have something rather different or more limited. And
my
how to pick.
I've done a lot of mediation on opposed renewals because it's G, it's F, it's the tenant giving up their livelihood. It's really difficult. The reality is, when it comes to rent, Myriam's right, do you need a mediator? You know, that's the whole purpose of setting directions, mandating that experts do reports, they have WP discussions, they do meetings, they then do a joint list of points that are agreed and disagreed. You know, as mediators, we're there to help as much as we can, but you know, parties are going to be informed by what their valuers say, and if the valuers can't really hack it out between them, then, you know, Myriam's quite right. It tends to be done without a mediator, albeit, you know, always there to help.
I've got two more. So one for either of you, actually. You talked about, Rupert, the right mediator, picking that was one of your top tips on your list. What does that mean beyond having someone who knows the area of law? How does one pick? How does one go about identifying whether somebody's the right mediator?
The reality is, the right mediator is the one that you've worked with before, but that presupposes that you've got experience of the particular mediator. Quite often I'm put forward at beauty parades where I pick up the phone and I explain my mediation style, but and beyond that, it's a matter of looking at their background, their record, but also talking to people within the firm.
Yes.
You know, within firms, you know, the reality is a solicitor's going to have 2 or 3 mediations a year, talk to colleagues that have done it, talk to former colleagues and take their opinions. But, you know, that really is the most you're going to get without these glorified beauty parades where, frankly, we'll say anything we can to get the gig. So I always wonder how much use they actually are. But I think it's just asking those that you trust amongst your peers to find the right mediator. And what right really means, if you've got a colleague you get on very well with and they've got a mediator recommendation, particularly if, they've met on kind of empathetic plane, it's almost certainly going to work for you, but it is difficult.
Robert, any thoughts on that?
No, I mean, as I said, the case I was talking about, they chose me, I think, because they wanted a high-profile judge who could command some sort of public confidence. Whether that was achieved is another matter, but I mean, that was very unusual, and it was so public. What Rupert is talking about is much more the nitty-gritty of the ordinary case, where you haven't got a lot of public people out there who are going to be looking at the result. So, as I said, it's horses for course there.
Good. And if you take one last one from me, it's position statements. And we're often asked representatives to provide a position statement. It just frankly strikes me as a bit pointless, because you know what the pleadings say, you know what the parties say, you've got correspondence passing back and forth, often over a long period of time, yet you need to put this position statement in. It's almost like a tick box exercise. So my question is, what makes a good position statement if you have to put one in, so as to avoid it just being a waste of paper?
We've got outcomes mediators are standardised forms, and they ask for confidential information for the mediator only. Because, as you say, position statements which are there to be seen by the other side is exactly that kind of antagonistic recitation of the law. We're so brilliant, you're all in veil. So actually what we prefer is a 2-page, and it's done as a form of questionnaire, but it's for the mediator's eyes only, because it tells us what we need to know in advance. Yeah. Without having the position statement, which just, it's another £2,000 worth of clients' money, or God knows what, on lawyers putting glorified skeleton arguments together, which aren't very helpful. So I don't like position statements, but I love these confidential questionnaires where parties expressly state, this is what matters to me, this is what I can give, and they are for the mediator's eyes only. And I think that's very useful. I've
seen those, and it speeds things up, doesn't it? Because it provides the focus, and that actually absorbs back to plenary session, or single. What do you call it?
The initial meetings, but
plenary session. The initial joint meeting, it kind of cuts through the need for that, because the mediator already knows because often that can be an extraction of information exercise, can't it? Good. Are there any other questions from the floor before we wrap this up? No? Good. Well, thank you so much for attending. We hope that you found it informative and of use, and provide some feedback. I think there might be forms circulating. We'll get you the slides by email, and there'll be drinks for those in the room, in the outside by the lifts. And thanks for all online, and hope you do it again on another occasion. Many thanks.
I'll say